Here's where Martel's argument starts to crumble. He's claiming that because the judge signed search warrants, essentially approving probable cause for law enforcement to search for evidence, the judge is now tainted and can't fairly preside over the preliminary examination. But the judge immediately challenges this logic. Here's the key distinction Martel is missing. Signing a search warrant and presiding over a preliminary exam are fundamentally different judicial functions. A search warrant is reviewed based solely on a written affidavit, no live witnesses, no cross-examination, just a document that says, here's why we think evidence is in this location. The judge reviews that document, determines if there's probable cause, and signs off. That's it. But a preliminary examination, that's a whole different ballgame. Witnesses testify under oath, the defense gets to cross-examine them, and the judge makes a fresh determination of probable cause based on live testimony. These are two completely separate processes, and the judge is about to explain exactly why Martel's argument doesn't hold water. And notice the judge's tone. They're not just skeptical, they're incredulous. How the hell do you jump to that conclusion? This is a judge who feels like their integrity is being questioned, and they're not about to let it slide. What happens when a defense attorney walks into court, tries to get a judge recused, and gets absolutely demolished for lying? You're about to find out. Welcome to a courtroom showdown that has everything: legal manipulation, blatant misrepresentations, and a judge who is not playing games. This is the case of People v. Darren Dwayne Wilson, and what you're witnessing is defense attorney Edward Martel attempting one of the boldest and most disastrous legal maneuvers you'll ever see. Here's the setup. Martel wants the judge recused, claiming they can't be neutral because they already signed search warrants in this case. Sounds reasonable, right? Wrong. The judge isn't buying it, and immediately starts poking holes in Martel's argument. But it gets worse. The judge accuses Martel of outright lying, not once but multiple times about key facts in the case. We're talking about misrepresenting which judge handled a co-defendant's preliminary exam, cherry-picking case law to mislead the court, and potentially engaging in forum shopping to get a more favorable judge. And just when you think it can't get any messier, prosecutor Miss Hughes steps in with legal precedent that completely obliterates Martel's argument. She cites a 2013 Court of Appeals case and a 1971 Michigan case that say judges who sign search warrants can absolutely preside over preliminary exams and even full trials. The courtroom tension is off the charts, so buckle up, because this isn't just a legal debate, it's a masterclass in what happens when a lawyer overplays their hand, gets caught misrepresenting facts, and faces the wrath of a judge who's had enough. Let's dive in. This is a devastating moment for Martel. The judge just accused him of playing fast and loose with words, which in legal terms means you're being deliberately misleading. And then comes the ultimatum: show me a case that says under these circumstances the court shouldn't hear it, otherwise you're wasting my time. That's judicial code for you've got nothing, and I know it. Martel cited a case about ex parte witnesses, but the judge immediately identified the fatal flaw. That case is about arrest warrants, not search warrants. An arrest warrant might involve live testimony or sworn statements, but a search warrant, it's just a written affidavit. No witnesses, no testimony, no live evidence presentation. The judge made their determination based entirely on the four corners of that document. And here's where Martel makes a critical admission. This relates to an arrest warrant, not a search warrant. So why cite it? Because he's hoping the judge won't notice or won't care. But this judge is meticulous, and they're not letting Martel twist the facts. The judge is essentially daring Martel to produce actual legal authority for his position, knowing full well he can't. And when a judge says you're wasting my time, that's not just frustration, it's a warning that sanctions might be coming. The judge just dropped the hammer. If it doesn't bear out, I can find it frivolous and sanction you. This is huge. Sanctions in court can include fines, disciplinary referrals to the state bar, and serious damage to an attorney's professional reputation. The judge is essentially saying, are you absolutely sure you want to put this argument in writing? Because if it's as baseless as I think it is, there will be consequences. And notice Martel's response, or lack thereof. The judge asks 3 times, how long will it take you to file this motion? And Martel can't give a straight answer. If your legal argument is solid and well researched, you should be able to knock out a motion in a few days, maybe a week. But Martel is fumbling. Why? Because he knows his argument is shaky, and now he's being forced to commit it to writing where it can be scrutinized, appealed, and potentially used as evidence of frivolous litigation. The judge orders a recess, but this isn't a courtesy, it's strategic. The judge is giving Martel time to reconsider, maybe consult with colleagues, and potentially realize he's about to make a huge mistake. But when court reconvenes, things are about to get even more explosive. This is absolutely brutal. The judge comes back from recess and flat out accuses Martel of lying. Not once, but twice. First, about which judge handled the co-defendant's preliminary exam. The judge had their staff research it during the break, and it turns out Judge Barr handled that exam, not this judge. Martel's entire premise that this judge had already presided over related proceedings, completely false. But the judge isn't done. They also call out Martel for cherry-picking the People v. Beryl case. Martel quoted one part of the case to make it sound like it supported his argument, but he intentionally skipped over the first part of that paragraph that actually says the opposite. The full text makes clear that when an affidavit is in conclusive form and no witnesses are examined, which is exactly what happened here, there's no prejudice in having the same judge preside over the preliminary examination. This is what lawyers call selective quoting, and it's a serious ethical violation. Attorneys have a duty of candor to the court, meaning they can't misrepresent case law or facts. The judge is saying Martel did exactly that, and the use of the word intentionally suggests this wasn't just a mistake, it was deliberate. When a judge says, "I hate using the word, but you lied to me," your case and potentially your legal career is in serious jeopardy. Martel tries to walk it back, saying he didn't specifically claim this judge held the co-defendant's exam, but the judge isn't having it. In fact, the judge offers to play back the recording to prove Martel said exactly that. When a judge offers to play back a courtroom recording in open court, that's the nuclear option. It means they're so confident in their position that they're willing to let the evidence speak for itself and embarrass the attorney in the process. Martel wisely declines and says, "I stand corrected," which is lawyer speak for, "Okay, I was wrong, but I'm trying to save face." He pivots to saying he's just preserving the record and means no disrespect, but the damage is done. His credibility is shot. The judge's response, "I don't know what your motion is because everything presented to me is not it," is a polite but devastating way of saying, your entire argument is nonsense and you've wasted everyone's time. Now it's the prosecutor's turn, and Miss Hughes is about to deliver the legal equivalent of a knockout punch. She's got case law, she's got facts, and she's about to dismantle what's left of Martel's argument. Miss Hughes just delivered a surgical strike. She cites People v. Cameron, a 2013 Court of Appeals case where a judge not only approved a search warrant, but then presided over the entire bench trial, and the appellate court said that was perfectly fine. In fact, they ruled it would have been ineffective assistance of counsel to even try to recuse that judge. That's how clear the law is. But she doesn't stop there. Hughes also brings up People v. Pitchford from 1971, where a judge approved a search warrant and then presided over the preliminary examination, and the court affirmed that procedure. These aren't obscure or outdated cases. They're directly on point and establish that Martel's entire argument is legally baseless. Hughes also makes a critical factual distinction. The search warrants the judge signed did not include the testimony that will be heard today. The warrants led to the discovery of evidence about the defendant's identity, but the judge has never heard that evidence before. So there's no bias, no prejudgment, no tainted decision-making. The judge is coming into this preliminary examination with a completely clean slate. And notice the prosecutor's confidence. She says she has a lot to say about the law and her own cases to cite, but she's willing to set them aside because the argument is already so clear. That's the legal equivalent of saying, "I've got more ammunition, but I don't even need it because you've already lost." Martel's argument is dead in the water. And here comes the judge's final accusation: forum shopping. Forum shopping is when a party tries to manipulate the system to get their case heard by a judge they think will be more favorable. It undermines the integrity of random case assignment and judicial independence, and courts absolutely hate it. The judge is essentially saying, "I know exactly what you're doing. You're not protecting your client's rights, you're trying to game the system." The judge even points out that they had to step into this case, implying Martel wasn't happy about the assignment from the start. And now, with this frivolous recusal motion, the judge believes Martel is just continuing his attempt to shop for a more lenient judge. Martel pushes back respectfully, saying he enjoys practicing before this judge and means no disrespect. But the evidence speaks for itself: misrepresented facts, cherry-picked case law, and a baseless legal argument. The judge requires the motion to be filed in writing, which locks Martel into his position and creates a clear record for potential sanctions. And here's the kicker: the preliminary examination, which could have happened today, is now delayed until January 2nd. Because the defense raised this issue, the defendant. This case is a perfect example of what happens when a lawyer overreaches, misrepresents facts, and tries to game the system, and gets absolutely demolished by a judge who's had enough. So what do you think? Was Martel justified in trying to recuse the judge, or was this clearly forum shopping? Do you think he'll face sanctions, or will he quietly withdraw the motion? Drop your thoughts in the comments below. And if you found this case as shocking as we did, make sure to hit that like button.